Hi, I'm Tom Fighter. Okay, so I get this question a lot. How do I get text messages in front of a judge to consider in an injunction hearing? Text messages are admissible in Florida courts to get an injunction or to defend against one. But you need to prove that the texts are authentic, or the court may not consider them as evidence. There are various ways to do this. You can take screenshots of the texts and just print those out and provide them to the court. You can provide printed out cell phone records of the text messages. Or finally, you can get subpoenas from the cell phone service provider. But that one can be tricky, and I'll talk about that more in a second. Most of the time, you only need screenshots of the text messages. If you can testify that the person who sent those texts is the other person, the judge should let them in. If you need to get subpoenas for text records from a service provider, that's the process that can get a little bit tricky and expensive. But we know exactly how to do it. The process I'm about to explain takes patience, organization, and determination. That's why most people give up, and that's why attorneys can charge a lot of money to do it for their clients. Here it is in a nutshell. All right, so we know that sometimes people will use other phones and send text messages, or go online and send spoof or fake text messages from an app or a website. So how do you prove that it's the other person who's doing it? Now, there's a lot of ways to do that. You can start by sending what are called requests for admissions. You can do interrogatories, or you can take depositions of any witnesses related to the case. Once you've locked in on what phone numbers, emails, and computers like IP addresses the other person used, you can then begin the process of getting the records from the service providers. All right, so here's step one. File what's called a notice of production from a non-party and the actual subpoena for production of documents from the non-party. The non-party is like AT&T, Verizon, or even Google, for example. You have to send both of those documents to the other party or their attorney as well. Step number two, you have to wait 10 days or 15 days if you send notice by email to see if the other party objects. If the other party objects, you may have to have a hearing in front of a judge to see if the judge will allow you to subpoena those records. Most times, however, there's no response from the other side, and you can just move right on to step number three. Step three, after the waiting period, you have to get the clerk of court to sign the subpoena and then you have to send it to the service provider. You can usually just do that by emailing it to the service provider's custodian of records. That's the term you need to know. And the custodian of records for any service provider is pretty easy to find with a simple online search. Step four, once you get the records, you have the records. You can provide them to the other party if you'd like, or you can wait for them to request copies. So there you go. Now you know how to get text messages, or even emails for that matter, from a service provider in an injunction case. If we can be of any further assistance to you, please don't hesitate to reach out.